I included this case and decided to brief it because it's a great example of fraudulent conveyance and intellectual property. And it's about the girls gone wild phenomenon, so it's a little bit colorful. I think they should call this case Lawyers Gone Wild, because there are so many lawyers involved and it's so complicated that the opinion on in this matter was 43 pages, single spaced. But we summarized it for you, and I'll go into the facts in a second. Essentially, the argument is that certain entities owned the trademarks and the intellectual property, mostly trademarks, associated with the Girls Gone Wild concept. And this is basically the main property that these companies own. This is their property. And it was developed, as everybody knows, into websites, into videos, into DVDs, into online pay-per-view, all kinds of stuff, and became a sort of a nationally known brand. So the allegation, and I'm just going to talk about it for a second before I go to the slides. The allegation was that this valuable trademark was transferred by the founder into another company, and for no compensation. In other words, this new company did not pay the original companies any money for the trademark. And it all boils down to that. Was that a fraudulent conveyance of intellectual property? The other thing that's kind of weird about this case, if it weren't weird enough, it's that it was started by this company, Argyle. Argyle was the recipient of the trademarks, suing the bankruptcy trustee for the original Girls Gone Wild company and trademarks. And the basis of the lawsuit is that the trustee was making remarks that that Argyle could not use the trademarks. And so Argyle actually sued the trustee. I've never seen this before. And then the trustee countersued for a fraudulent conveyance. I don't know whose advice they were listening to, but I think they figured a good offense is the best defense. Anyway, that's why if you look at the first slide. So there came a day, November 15th, 2011, when GGW Marketing and GGW Brands, stands for Girls Gone Wild, of course, assigned the trademarks to Girls Gone Wild to Path Media, a company owned and managed by Mr. Francis, the founder of the entire Girls Gone Wild concept. And there was a little problem here. The debtors didn't get anything back. So they're giving away, the debtors are giving away their most valuable possessions, the raison d'etre of these debtors, the Girls Gone Wild intellectual property, and for nothing. So they give these assets to Path Media. I wonder why. When does a debtor give away assets for nothing? When the debtor is worried about creditors, obviously. Not much changes in this world. Anyway, that's what happened. I'm sure maybe some of the girls on the beach might have, even the girls that went wild would know that something was up here. Anyway, the debtors continue to maintain the trademarks by paying registration fees and by making payments to attorneys for Path Media. Why would they do that? It's as if they still own them, and they continue to use them. In May of 2012, the story continues. Francis attempts to terminate the original companies. Let's just get rid of these companies because they owe too much money. Let's just terminate them. Well, who needs them anyway? All the good stuff has been transferred out. On February 25th, 2013, Path Media sends a notice of termination of licenses to the debtors. They can't use the trademarks that they gave away for nothing. Now they can't even use them anymore. Also on February 25th, Path Media entered into a new licensing agreement with GGW Direct and licensed the Girls Gone Wild trademarks and all that entailed to GGW Direct for $274,250.52. And this fee was paid by GGW Direct to Argyle, who Argyle appeared to be a representative, an affiliate to Path Media. Of course, it's another entity controlled by the founder. The debtors, the original debtors that Mr. Francis attempted to terminate out of existence, of course, did not receive any consideration for the termination agreement, and they certainly didn't get any consideration for this new license agreement. Oh, by the way, Francis's girlfriend was the manager of Argyle. And Francis, of course, owned Argyle as well. On February 27th, 2013, the original debtors filed for bankruptcy, and that includes GGW Direct. And the trustee, after given permission, revoked the cancellation of GGW Marketing and by motion was authorized to file a Chapter 11 petition on behalf of that company as well. The trustee representing all these debtors sought to avoid and recover the assignments of the trademarks for the benefit of creditors of the original companies, either that Joseph attempted to terminate and now in bankruptcy, to avoid the termination agreement and to recover the value of the license fee that was paid by Direct. I think when the trustee reviewed all these facts and what happened here, he must have thought this is going to be like shooting fish in a barrel. This is clearly an obvious fraudulent conveyance. Anyway, trustee argued, built his case slowly, argued the importance of the trademarks, Francis's relationship with the debtors and the other companies, and the debtors' continued use of the trademarks to support his claim for actual fraudulent conveyance. Trustee argued that the assignments left the debtors insolvent because the debtors lost their most important asset. What's Girls Gone Wild? What's GGW without Girls Gone Wild? Nothing. Additionally, the trustee argued that the debtors received less than reasonably equivalent value in exchange for the fee because previously they did not have to pay to use the trademarks. I think that's a fair argument. The The defendant here argued that, and I'll get into that in a second, but they argued that this is a fair fee for the trademarks. This is market value. This is what should be paid. The only problem is they're paying for what they used to own. So it doesn't make a lot of sense. Yes, it's market value, but we used to get it for free. So why should we pay for it now? It's kind of a strange argument, in my opinion. Finally, the trustee argued that the termination of the license was also, the timing of it was suspicious, and the debtors were insolvent, etc., etc. Like I just said, Argyle argued that, the second thing it argued was that, hey, this is market value. The first thing it argued was that the transfer of this asset was not made to defraud or harm creditors in any way. We're just transferring the asset to facilitate the efficiency of having all the intellectual property in one entity. That's all. I just don't understand. I don't understand an argument with so little credibility, but that was their argument. They did what they could. So is the assignment of the trademarks to Path Media a fraudulent conveyance, an actual fraudulent conveyance under 548A1 capital A, and or a constructive fraudulent conveyance under 548A1 capital B? Were the termination agreement and license agreement fraudulent conveyances under 548A1A or A1B? This is the statute. I'm not going to read the whole thing, but the trustee may avoid any transfer if the debtor made such transfer, incurred such obligation with actual intent to hinder, delay, or defraud. So that's actual fraudulent conveyance, 548A1 capital A. And there's no insolvency requirement. There's no valuation requirement. The only requirement is, was there an actual intent to hinder, delay, or defraud? Was this done in bad faith? And the judge will look at badges of fraud to determine whether that's the case. In constructive fraudulent conveyance, it doesn't matter what the intent was. It could have been a lot of good faith. It could have been a great intent. It doesn't matter. It's the value of the property that's being exchanged. Maybe the intent was to centralize the location of these trademarks. That's fine. But if the trademarks were assigned, if the trademarks were transferred for no payment, then there's going to be an issue that was this reasonably equivalent value in exchange for such transfer. And it doesn't matter if there was a bad intent or not. However, in this section, in constructive fraudulent conveyance, there must be a showing and proof that the debtor was insolvent at the time of the transfer. Otherwise, it's not a constructive fraudulent conveyance. Why is that? Because who cares? If the debtor is solvent, if the GGW debtors were solvent at the time of the transfer, and the transfer did not render them insolvent, and they were able to pay all their creditors, who cares if they didn't get enough money, or they got nothing, or they gave it away? What's the difference? Creditors aren't being hurt. They're going to be paid anyway. The debtor is solvent, meaning it has more assets than liabilities. So creditors are going to be made whole. So both elements are important. Well, no big surprise here. The court found that under 548A1 capital A, the trademarks were property of the debtors. The assignments were transfers And the assignments were made within 2 years of the date the debtors had filed for bankruptcy. So they were within the look-back period under fraudulent conveyance. The court noted that the debtor's business depended on the trademarks. I think even some of the girls that went wild would agree with that. I mean, that's pretty obvious. The court, I mean, no disrespect for the court to the court. What I'm saying is that this was a no-brainer. The court further noted that the transfer of the trademarks would undoubtedly have led to insolvency because these companies totally depended on these trademarks. It's all, and it was about girls going wild. Can't take away the girls going wild and still have a company here. Additionally, it was beyond dispute that there was a special relationship between the debtors and Path Media. Francis controlled both, and you can throw in Argyle as well. And that Path Media was formed for the purpose of shielding Francis's and the debtors' assets from creditors. That's why it was for. There's a finding here that it was formed to defraud creditors. It wasn't formed because of the great benefits of centralizing the intellectual property assets. The court found that as far as the transfer of as far as to the assignment, the assignment of the IP rights, the court held it could not determine whether the debtors were insolvent at that time. Remember, it's at the time of the transfer because the trustee did not provide enough evidence on that issue at that time, which was November 15th, 2011. So, it doesn't matter. The court found that the assignment was avoidable anyway as an actual fraudulent conveyance. With respect to paying the license fee for something that they gave away before, the court found that this was an actual fraudulent conveyance and that Francis had the original companies actually empty their bank accounts before filing for bankruptcy by paying this licensing fee to Argyle. On a side note, I was kind of disappointed by that number with all these girls going wild, and that's all he had left, $274K. Anyway, 548A1 capital B, the court found that the payment of the fee was not a reasonable equivalent value because they had continued to use the debtors had continued to use the trademarks for 3 months without paying any fee. And anyway, they owned the trademarks prior to that. So I think there was essentially an inherent absurdity to that argument. Finally, the court found that the debtors were insolvent at the time of the payment of the termination and the payment of that fee. So the court was able to also find that to be a constructive fraudulent conveyance and that the trustee could recover that fee.